The Kris Wu Public Opinion Case. Gate of Truth Series. False cases will collapse. Truth endures. Ep.2. Second instance verdict. 7 judicial red flags, fully explained. The case was announced in November 2023, but has the case really ended? If it has, where is the written judgment? The system dared not put it in writing. Without a formal judgment, nothing can be closed. Today, we unpack the 7 judicial red flags in the second instance verdict. Let the truth surface on its own. Project Light Axiom Reality Case, Ep.2. Red Flag 1. The judgment is missing. The core evidence is nowhere to be found. July 25, 2023. Second instance concluded. Officials waited a full 4 months and only announced the verdict on November 24th. To this day, no formal judgment can be found online. No ruling document. No case number, no cited statutes, no presiding judge's signature or court seal, not even a plaintiff or a pseudonym. All the world can see is a one-page, press-style summary, copied and recycled, endlessly forwarded, conclusions without grounds. Under Chinese law, if a hearing is not public as an exception, reasons must be stated, and verdicts must still present the legal basis as needed. But what do we see now? No content made public, no reasons explained. When no written judgment exists, procedural requirements are skipped wholesale, and adjudication becomes unverifiable. What the release shouts is not a lawful judicial decision, but an uncheckable result notice. This is not transparency. It is the removal of legal actors, leaving only a shell of deterrence. The absence of a judgment is the biggest red flag. In this case, no legal basis, no chain of evidence, and no procedure. Without documents, a verdict is just a line, not a verifiable judicial act. Documents are the skeleton of justice. Remove the bones, and all that remains is a story. Without a judgment, no decision can be confirmed or take effect. Red Flag 2. Identical publication times. A scripted rollout. November 24th, at 11:05 a.m. and 11:06 a.m., 6 leading official accounts posted the verdict within the same minute, in perfect sync, identical wording. The rest of the media followed instantly, creating a wave. Such uniform timing doesn't occur naturally. It shows both content and timing were coordinated before the announcement. That's more like result-first propaganda, not transparent judicial information. 11:05 and 11:06 echo the birthday November 6th. 6 official adults posting at the same moment, plus the number 13. This is not law. It's psychological cruelty, a choreographed ritual of humiliation, and blatant number sorcery. All verdict info we see stops at infographic summaries. Charges and terms are clear, but the judgment is missing. No facts, no evidence chain, no law cited. This case does not involve minors or state secrets. When conclusions are magnified and grounds are hidden, justice cannot be audited. When procedure is concealed, the public can only accept the end, and the conclusion monopolizes, impersonates the truth. Red Flag 3. Abnormal and misused legal wording. Textual holes exposing a hollow trial. A proper second instance final decisions held use substantive phrasing. The court hereby judges as follows, but the public text says, ruling, appeal dismissed. In legal terms, judgment vs. ruling have distinct scopes. Judgment, substantive issues. Ruling, procedural matters. If the second instance finished trial, that's a substantive outcome and should be rendered as a judgment. Yet what we see is dismiss the appeal, uphold the original procedural, not substantive phrasing, a concept mixed up with the nature of the case. This wording mismatch creates another logical contradiction. When legal language diverges, the decision's nature can be checked. If the nature is unclear, credibility collapses with it. Ruling equals procedural decision, upholding equals substantive conclusion. They dare not call it a judgment, nor admit the appeal had merit. Their second instance resembles a farce, a robber announcing after the theft, "I've decided I didn't do it." More vividly, on July 25th they solemnly declared, "We pooped," headlines echoed. Second instance, hearing held. 4 months later came a statement. Actually, that wasn't the second instances, it was the first's. Reason given. Appeal dismissed. So tell us, what was the July 25th hearing then? And what exactly was made public on November 24th? Announce a public verdict, yet dismiss the appeal. Isn't that like serving up the first instance's stuff and claiming you didn't eat it? Then saying, "We didn't." It means, first they asserted the second instance exists, then they denied it ever happened. They dare not truly judge, nor admit the appeal has merit. This is their judicial logic. Excrement time travels, time flows backward, and the Rashomon loops. These metaphors are not mockery, the plot itself is that graphic. Reality is so absurd it needs metaphor to explain. A lawyer wrote, "Whatever the law, don't lose common sense." Abnormal wording. Item 2. A proper second instance document must include 4 basics. 1. Facts of the offense. 2. Chain of evidence. 3. Applicable statutes and reasons. 4. Signatures and responsible actors. But in the official text, no statute numbers, no case narrative, no plaintiff identity or alias, no time, place, or act specifics, no evidence types, collection methods, or validity. Instead we get, the court upon review holds decision to execute vague procedural language, not judgment language. They also keep stressing attendance, yet never mention the hearing process. What happened in court? No one can know. If the trial were lawful, why avoid the court judges as follows? Why cite no statute at all, leaving no detail to verify? The court holds means no judge's name, no panel list, responsibility vanishes. Remove the subject, and the duty evaporates. The court holds replaces signatures, no accountable entity. This violates judicial norms and the system of trial accountability. An unsigned conclusion has no legal force or credibility. Mismatch hammer. This is not a judgment, it's mass trickery. Abnormal wording. Item 3. Evidence conclusive became evidence true and sufficient. For years, Chinese announcements have almost always said, "Facts are clear, evidence is conclusive." That phrase is not only legal jargon but a collective memory of credibility, a cognitive imprint. Yet this time, they switched to evidence true and sufficient. Just one word changed, but it weakens the key force of clear and conclusive. Why change it? Were facts unclear? Was evidence not conclusive? Or are they dodging future scrutiny? When language is altered, truth is warped. Sharp justice lies not in the term of years, but in whether evidence is conclusive. That is the inescapable question. Red flag 4. The hearing process vanished, only a verdict was proclaimed. A normal second instance report covers arguments from both sides. But neither on July 25 nor on November 24's announcement was the hearing process mentioned. Who was the judge? Did defense counsel appear? Were witnesses and evidence tested? All erased. Each notice simply repeats the conclusion, while clashes of argument, evidence, inquiry, time, place, and aliases, not one word. No courtroom footage ever. A secret trial in all but name. Without process or basics, there is no procedural justice. If the process is dark, the conclusion must be false. Red flag 5. Judges' identities missing in unsigned trial. A normal judgment lists judge as assessors and clerk and the panel members. But in this unprecedented media case, only one vague line remains. The court holds no signature, no panel list, no verifiable responsible party. That violates transparency and basic professional dignity. Law is written by people, so people must sign. Yet here, they won't even name the judge. An unsigned verdict is either unpublishable or non-existent. A lawyer wrote, "Whatever the law, don't lose common sense." An unsigned verdict is either unpublishable or non-existent. First plus second instance. No presiding judge named, no panel list, no clerk's signature and seal, no one to hold accountable, no one responsible for the conclusion. Red flag 6. The paradox of attending a verdict, a phantom of oversight and a Rashomon. Both first and second instance notices end with, quote, "Officials of the Canadian Embassy attended the verdict." Reconstructing the timeline. First instance hearing, June 10, 2022. No verdict in court. 5 months later, the decision was posted on November 25 with no hearing that day. So when exactly did this attending the verdict take place? Second instance hearing, July 25, 2023. Again, no courtroom verdict. The Canadian Embassy was denied attendance at the second instance hearing. 4 months later, November 24, the verdict was posted. So this time, where did they attend the verdict? Did embassy officials enter any venue? When there is a hearing, there's no verdict. When there's a verdict, there is no hearing. How does one attend it? Courts don't reconvene on verdict day. That's basic common sense. Judgments are either collected by parties' lawyers or sent by post. In short, attending a verdict cannot occur in reality. Both first and second instance notices ended with, quote, "Officials of the Canadian Embassy attended the verdict," and the second trial statement said, "The Canadian Embassy was informed." Lianhe Zhaobo reported, "The Canadian Embassy was denied attendance at the hearing." Reuters reported, "Canadian diplomats denied access to Kris Wu's appeal trial in China." Legal delivery of judgments. When verdicts are scheduled, courts don't reconvene. Basic common sense. Judgments are delivered via 1. In-person pickup with signature, 2. Registered mail, 3. Electronic means fax, email, messaging, 4. Are by entrustment or transfer or notice. In other words, a verdict is a written act, not an event. There is no venue to attend a verdict. Verdict on-site event. This is wordplay twisting logic into illusion. The so-called attendance oversight is a contrived photo op in words. What is hinted as transparency and third-party oversight is, in fact, a false, illogical Rashomon. With illusions of oversight and semantic tricks, they cover a trial that can't see daylight. Not oversight, but staging. Not attendance, but self-contradictory plot hopping. One word attended has neither legal fact nor time logic. It's not reporting a scene, but manufacturing trust as illusion. Red flag 7. Official notices appear, disappear, open becomes half open. A case of unprecedented impact based solely on online reports leading straight to arrest and conviction. No police complaint has no public judgment, only press releases. One netizen told Method the official pages about the Caciquip appearing and disappearing. When people questioned the disappearance, the page reappeared for a while, then vanished again later. So on August 16, 2025, I checked all levels of official sites. At that time, all notices were visible. The only anomaly, on the original source site, searching Kris Wu returned nothing at all. It's as if the beginning was skipped on purpose. The moment you open the page, you're pushed straight to verdict from internet posts and public mood directly to legal labeling, then onto a crescendo of media amplification. While making this video, I verified the netizen's claim again. Sure enough, something changed. A second instance court's page quietly added a follow gate. Now, without following, you only see half, and the hidden 50 includes the key lines. Notified the Canadian Embassy. Verdict to be scheduled. Plus, upon review, evidence is true and sufficient. and embassy officials attended the verdict. These omissions aren't coincidence, they reveal deeper control logic. They're not only hiding truth, they're tracking truth seekers. As everyone knows, PRC social platforms require real names. Follow looks like access control, but it's identity binding. Each click of follow logs your account, device, location, and time. Follow is a surveillance gate. It's like a voluntary signature, making tracking easier and more precise. A silent warning: be careful, stop digging. When concealment turns into instinct, light hits the sore spot. At the start, they used Wu Fan in anonymized form. This invisible handling looks routine, but foreshadows evasion of responsibility. From anonymity to media escalation, the name Kris Wu was nailed to the cross and displayed for 3 full years, then appeal dismissed, hands washed, everyone vanishes. The whole arse is a magic trick. First timid, then manipulative, then a getaway. This case lost its legal footing from the very start. It began with online reports. No one filed a complaint. By the end, there was never a plaintiff in court. Across 3 years, not a single courtroom image. Even the initial notice is partly hidden. No plaintiff, no party to sue, no judgment or case number, no way to verify proceedings. All this means the so-called trial may never have truly existed. Where the light is covered, truth begins to shine. While I was exposing these anomalies, my Weibo account August 17-31, 2025 posted essays like 7 red flags and was banned on Sep 1 for harmful political content. It was my 4th banned account. Many more voices for Kris Wu have long been erased. All of this shows the official stance on this case is singular. No dissent is allowed. From these 7 red flags, we can clearly see the second instance verdict was not the result of due process, but a tightly orchestrated opinion operation. It wasn't law at work, but power, not just as speaking, but power endorsing. It wears a legal robe, but is a scripted media war. Those who fear scrutiny cease to hide and to silence, but false cases will collapse, and the truth will surface. Each red flag is a crack that can't be plastered over enough to shake the foundations of this false case. And the 8th red flag will expose the anchor of this empty case. Next episode, we enter the fatal point. The 7/19 account hacking incident. Kris Wu's Weibo was spoofed to post a show Luo-style confession letter.